as the chair or the speaker requested, the 1999 Constitution, as amended, the 1999 Constitution, as amended, Mr. Speaker, provide for a personal Islamic law in the Constitution. The Constitution did not envisage the dynamism and the development coming off in the country. In 2003, the Constitution did not recognize that the Islamic commercial law, Islamic company law, Islamic international law, Islamic public laws. In 2003, Mr. Speaker, Taj Bank came up under the commercial Islamic law. In 2019, another bank came up under the commercial law. That means the Jaiz Bank, not the Taj Bank. The Jaiz Bank was in 2004. The Taj Bank came in 2019. Mr. Speaker, sir, if you look at the personal law, it only encompasses marriage, divorce, and the inheritance. Therefore, what I'm requiring is the removal of
the issues surrounding the particular section in reference, especially at the various constituent assemblies leading to the 1979 Constitution, the 1989 Constitution that was not promulgated, and now the 1999 Constitution. Mr. Speaker, the drafters of the Nigerian Constitution are very conscious of the secularity of the Nigerian nation, and also very conscious of the sensitive nature of religion. And I remember the 1976 Constituent Assembly, the 1979 Constitution, was very, very contentious on this matter until the then federal military government came in to stop further debate on this matter and took a decision that the application of Islamic laws will only be constrained to personal matters, which has to do with administration of estate and some other issues. Mr. Speaker, we have to be very, very cautious of whatever we do to alter the Nigerian Constitution in a manner that will further widen the divide that we have as a country. And in any case, Mr. Speaker, like my previous colleague said, the matters which my colleague seek to address by this proposal is already covered by existing laws. The Kama law, covers regulation on issue of finances and allows for application of Islamic principles of financial transaction. The same thing with the CBN Act, like you rightly said. And the moment we allow the Constitution to be altered to take care of all manner of interests, we will no longer be in the state where the sanctity of the Constitution is respected, and the intent of the drafters of the Nigerian Constitution via or as regards to the secular nature of the Nigerian nation might be threatened if we allow this to go on. Mr. Speaker, I sincerely think that this bill should not pass on for the second reading.
Speaker, I think we need not lose sight of what the proposer of the bill intends to achieve. I understand how sensitive matters related to religion are, especially in this country. But the fact of the matter is we cannot treat religion issues in isolation. There are issues that we must bring to the front burner and discuss, irrespective of how sensitive they are. I didn't want to stand, but I looked at the sensitivity. Even from the argument, you could see the sensitivity that is driving the sentiment that is driving the argument. But if we focus,
Honorable Ali, approach the chair.
If we focus on what the bill intends to achieve,
Honorable, approach the chair.
The bill intends to review the description of Islamic law, which means it's already enshrined in the Constitution. What it seeks to achieve is to review the description. So it's already in the Constitution. I don't understand why we will see it as something that will lead to snowball into a crisis or what have you. This is what we have done that over the years that has led us to not make progress on certain issues. It doesn't matter how sensitive these issues are. We must be able to debate them. This is what our people sent us here to do. You know, if we run away from discussing a problem, if we assume it to be a problem, and we're running away from discussing it, how will you provide a solution to it? I will agree and accept the fact that there is need for further, broader consultation. But for us to run away from the problem, for us to drop it and say it's not an issue to be discussed on this floor, I don't think it's something that is acceptable.
The Constitution mandates our government that they shall not adopt any religion as a state religion, meaning that Nigeria is a secular state. Number two is the fact that Section 38 is very clear as to the rights given to all Nigerians in terms of choice of religion and how they worship. Section 2 goes further to say that Nigeria is a federation consisting of the federal government and then the state governments, giving the states the liberality to adopt whatever kind of law they want to use in governing their people. And that's why we have some states with all this Sharia law and all of that. They are permitted to do it, the State House of Assembly. But the Constitution, as a ground norm that governs all of us, the traditional institutions, the Obas in the Yoruba land, the Igwe in the east, the Shekiri, the Fulanis, the Hausas, gives us only one right, the right to choose whichever one we want. We can therefore not allow this constitution to become so filled with frivolities that is supposed to be